Hello. Just wait for some people to come on. Hopefully you can hear me. I don't know. Maybe. Hey, Elle's on. Hi, Elle. Can you hear me okay? I'm actually on a laptop now, so I've got no idea how the sound is. Am I audible? Hello, testing. 1, 2, 3. Aloha. Oh, that's great. Thanks, Elle. So in this episode, I better do my intro. Sorry, I'm getting very tired. I went to the gym earlier and then, whatever. So, do you go to the gym, Earl? Just wondering. Since you're the first commenter. I used to go quite a lot back when I was in university because the gym was included, but, now things are a little bit different. So I'm doing a trial. So basically, use the gym for a little bit for free and then see what happens. No worries. So may as well do the intro now. So g'day friends and foes. I'm Arjay Martin. And this is TINLA episode 64. And what this one is entitled, if I can read it. No, I can't. But basically, it is concerning the COVID directions / COVID lockdown, shutdown, whatever you want to call it, legality case in the courts. And my particular ones involve the Queensland courts, but it applies to the rest of Australia anyway, especially we'll get into some other little bits later. So basically, as I said in a video I just did 20 minutes ago, half an hour ago, whatever it was, that basically I had a political rally that I was trying to do in Surfers Paradise that was illegally opposed by the government, by a police officer in her own personal capacity, that then went through the magistrates court and then the district court. Then I was contemplating appealing to the Supreme Court. In the district court, I had costs awarded against me of $6,875. Luckily, there are some very generous people that can actually, maybe even some of those can't even afford to be generous, but have been lovely enough to donate some money to the GoFundMe account anyway. And, unfortunately, everyone's hurting now, besides the mega billionaires that magically have made more money under COVID than, they had beforehand. Despite that, unless you're a government worker, then, you probably are worse off. Anyway, so the last time I checked, I think it was $3,800. Something just hit the roof of the car. I think it's like a bat or a bird or something in a tree above me. Probably pooped on my car or dropped a little seed or something like that. Anyway, so then I was looking at appealing to the Supreme Court under Section 112 of the District Court Act, or District Court of Queensland Act. There's no appeals directly from the Magistrates Court to the Supreme Court. Under Section 113 of that same Act, the District Court has the same powers as, and also 69, the court has the same powers as the Supreme Court's Court of Appeal, and that's when it's on appeal from the Magistrates Court. So I submit that the District Court did in fact have jurisdiction, but the judge claim that there was no jurisdiction. And anyway, I still believe that's incorrect though. So with the different court layers, so I may as well explain that until, hopefully more people come on. We did have quite a few viewers in the previous one, and if the video cuts out, sorry, I'm trying to bum a free Wi-Fi from a shopping centre, so that's why I had to do the previous video at 6:30 roughly instead of 6 o'clock, because the other shopping centre I went to didn't have Wi-Fi reception in a car park, and it was a bit too busy for me to sit in the shopping centre and do these videos. And again, I'm losing my voice, sorry. So anyway, so in Queensland, you have the Magistrates Court, and that doesn't have any kind of appeal panel or whatever. Then you have the District Court, so I'll do that as a thicker band. So with the District Court, you have the original jurisdiction District Court, and then on top of that you have like a Court of Appeal, but the Court of Appeal usually just refers to the Supreme Court's Court of Appeal. And hi Mary as well. Yeah, so it could have been $30,000 that I was charged instead of $6,875, but it is what it is so far. So Mary just said, so wrong charging you that amount of money. They are so allegedly corrupt. They make up fees and how they feel on a day. They should not be able to get away with this. Yeah, so there is some supervisory bodies in relation to legal costs as well, as I explained in a previous video, but I get what you're saying. So as I said, there's a magistrates court, so that's also the equivalent of a local court, say in New South Wales. Then you have the district court, so that's like a county court in Victoria, and that has two layers. You have the original jurisdiction layer and then the appellate jurisdiction. So if you have a matter from the magistrates court or from the original jurisdiction of the district court, then you can appeal things up, and even from the Supreme Court you can appeal to the High Court. But when you get above the district court level, the appeals basically require permission. They call it leave. So you have the leave of the court to appeal. And just say if you go to the Supreme Court and then you lose and you try and appeal it to the High Court can just say, nah, too bad, basically. So then you have the Supreme Court again, or do the wide band. So you've got the original jurisdiction matters, and then you have the appellate court, which is called colloquially the Court of Appeal, because technically you could say the district court's Court of Appeal exists too, but when people refer to the Court of Appeal, they're just talking about the Supreme Court's Court of Appeal. Then above there you have the High Court. Again, they've got the original jurisdiction, so that is usually for federal type matters. So some examples are if you are trying to get certain what used to be called prerogative writs, as in it used to be the prerogative of the Queen if they wish to issue those writs, but then they got renamed basically constitutional writs. So you have things like mandamus, so that's to force someone to do something, prohibition, to prevent them or stop them from doing something, certiorari, that technically isn't a constitutional writ because it's not in the Commonwealth Constitution. It's still a writ, but using it in a High Court for federal or Commonwealth jurisdiction matters, it must be used with other writs as well. You also have declarations and maybe a couple other little things too that you can do in a High Court. Also, if just say there's a resident of one state suing another or resident from another state, that again is original jurisdiction of the High Court, even if it's only, a contractual matter or something like that. And then you have the High Court's appellate, jurisdiction, and really you still really have appeals to the Queen above that from the High Court. But a silly thing is that the High Court they're supposed to grant certificates where it's warranted under section, is it 74? Constitution, or is it 76? Wasn't going to talk about this, but I'm just trying to get more people on too, so it's not 74. 76, try that. No, that's original or additional original jurisdiction. 74. I'll just find the relevant part. Previous powers. 70. Yeah, so I may as well go through it. So section 75 of the Commonwealth Constitution says about the original jurisdiction of the High Court, and it doesn't mean necessarily that you have to go to the High Court, because the Federal Court, for instance, was created, it's not a body of the Constitution, but it was created as an additional court to relieve High Court matters. So they can deal with some original jurisdiction of the High Court matters. Someone could argue that that's incorrect, but that's how it's used in practice. So they've got 5 different subsections here. So in all matters arising under any treaty. So if someone is talking about the GATT treaty as an example, so that's the generally accepted, what's GATT? I don't want to misinform people, so I'll just check it. Where does it say what it stands for? So General Agreement on Tariffs and Trade. So if someone is suing the USA via our courts, via our High Court, saying, hey USA, you are calling a product Aussie wines or something, and it's made in the USA, so therefore you can't do that, blah blah blah, they can take that to the High Court. You also have, just going back, matters affecting consuls or representatives of other countries. So Bilbo is a French diplomat and runs over someone in a car, then the person would sue in the High Court, as an example. 3, in which a Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party. So if you're trying to sue the Commonwealth government, as an example. 4, between states or between residents of different states, or between a state and a resident of another state. So again, you might have the Commonwealth against Tasmania as an example. So, which, a famous version of that is the Franklin Dam case. And 5, in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth, the High Court shall have original jurisdiction. Then section 76, if the touchpad doesn't do right clicks, additional original jurisdiction. So the Parliament may make laws conferring original jurisdiction on a High Court in any matter. So the Commonwealth Parliament can say, what would be a good example? No, it's just a fictional example, but they might say for all Admiralty law matters, which the courts aren't, or exercising admiralty law or maritime law all the time, only for shipping cases, unlike what the likes of Romney Stewart with the Justinian deception, Stephen Spires, I think, as well, and originally David Wynne Miller claimed. You hear this stuff about birthing certificates because a berth is where a ship goes. So when you misspell birth as in BIRTH and put an E there, then it sounds like it's a ship. And, you have the dock in the court and all that other stuff, which is just fake law. So arising under this constitution or involving its interpretation, arising under any law made by the Parliament of Admiralty and Maritime jurisdiction, so there you go, that's in there, and relating to the same subject matter claimed under the laws of different states. And 77. Just trying to skip ahead to where it says about the Queen in Council. 79, 80. How are you all going anyway? Okay, search this act. Alright, Queen. There was section 74. So, I'll just go back to the video quickly. So, with the Queen, technically, it's part of the Constitution, so you can't really get rid of it, despite that there are a couple of acts purporting to limit and then get rid of appeals to the Privy Council, as an example. But Section 74 says, appeal to Queen in Council. No appeal shall be permitted to the Queen in Council, and it's not actually the Queen, sitting in on the case, even though technically they can. It is the Queen's courts. They can, the Queen can do what she likes. And of course, it changes to King when you have a King in power instead of the Queen. But they have their little council called the Privy Council. So a lot of people have heard, Rod Culleton's appealing apparently to the Privy Council or something like that. That's what it's referring to. So, no appeal shall be permitted to the Queen in Council from a decision of the High Court upon any question, howsoever arising as to the limits inter se, which means between, of the constitutional powers of the Commonwealth and those of any state or states, or as to limits inter se of the constitutional powers of any two or more states, unless the High Court shall certify that question, or that the question is one which ought to be determined by Her Majesty in Council. What that really means is, if you have a case that's like the Commonwealth against Tasmania, as an example, and someone wants to appeal that to the Queen in Council, looks like people are nearly having a fight out there. There's a woman that's forcibly hugging a man. But anyway, I don't know if maybe the man's got some mental health issues or something. He just punched the wall and kicked the wall, and now he's kicking more. But anyway, it'll be interesting when security comes. Anyway, so if, just say in, just say the Commonwealth Government sues New South Wales for something, then New South Wales wins or loses, and then one of the parties wants to appeal to the Queen, then the High Court is supposed to issue a certificate for that. But it does continue, and there are other areas where they don't need to issue a certificate, and basically the Queen can just intervene if she really wanted. But a lot of people would complain about that. So, the Queen's interfering in Australian law, because they don't understand that Australia is a self-governing colony of Britain and a possession of the Queen, as it says in the Commonwealth Constitution. But anyway, so just checking the messages. Yeah, Mary's saying freedom of speech became expensive. Yes, indeed. So again, with courts, you have a thing called access to justice or access to justice issues, and one of which is that it costs so much to do anything. People can just look up filing fees of XYZ court and see how much it is, as an example. Mary also says, I would rather a legal person like you represent me, a person with great ethics, morals, that stands up for what is right. Thank you very much. And, I should have been a solicitor by now if it wasn't for this COVID stuff. But anyway, so I have delayed long enough. Basically, I went in on Monday to appeal to the Supreme Court, and then I was there for 2 hours because they were refusing to accept the filing, which again I can't really discuss at this stage. But they eventually accepted it because they took 2 hours to accept it instead of 20 minutes, and I did get a fine for parking, but it's $266 well spent if we win and get rid of this tyranny that we've got. And also, a lot of people have been telling me, hey, including some lawyers and whatever, hey, just don't appeal, or if you appeal, just use that as leverage to get out of your $7,000 nearly costs awarded against me. But as I say to them, it's not about me. It's about, part of it's about me because, without repeating what standing is, but, I have standing to bring the case because of the particular situation and circumstances. But basically, the gist of the case is about COVID directions and, the tyranny that we find ourselves in. We've got borders where you can't cross because the states say, Queensland hospitals are for Queensland, or for Queenslanders, I should say, in the words of Anastasia Palaszczuk, or words to that effect, that apparently, might well have cost a poor lady in Ballina the death of her twin babies because she had to fly to Sydney instead of going just to Brisbane, as an example. And then before that, in Queensland, we had a 500-kilometre travel limit if you lived in the middle of Whoop Whoop, or 50 kilometres if you were, anywhere else in Queensland. And Victoria has the 5-kilometre limit as an example. But of course these laws don't apply to people that work for the government because they wouldn't have that, and the workers will get pissed off, putting it nicely. But you also have the likely prospects of mandatory vaccinations. We have state premiers and the Prime Minister saying about mandatory vaccines, and then the Prime Minister backtrack slightly to say, I don't mean mandatory, I just mean you won't be able to do anything like travel or go in public transport or, get Centrelink or anything if you don't get vaccinated. And that's very, very paraphrased, and reading between the lines. But he basically said, again, paraphrase, that we don't have to force everyone to have a vaccine. We can just coerce people into it. And again, that's not his words, but, that's effectively what it is. We also have Western Australia as an example, in a particular act saying they can force people, hold them down to vaccinate them, etc. So that's banned as a part of Section 51, subsection 23A of the Commonwealth Constitution. So no government can force medications, or as they call it, so the words are to the effect that the government, or any level of government in Australia, can provide dental and medical services so long as it does not constitute civil conscription. with the border issue, so that reflects on two particular sections of the Commonwealth Constitution. One is 117, which relates to discrimination by one state, really, or territory, but it doesn't say or territory, but you can read into it those words as well. But discrimination by one state to residents of another state. So, in New South Wales, people trying to cross the Queensland border, as an example, have to get permits, that kind of thing. There is a travel bubble thing for some people, like in Moree now, it's been extended, and previously for Tweed Heads, etc. But just as an example, you also there's a farmer in Victoria that was just across the border from New South Wales where his farm was, with however many thousand sheep, and he needed to get 41 tonnes of hay to 15 kilometres away or whatever across the border, and he tried getting COVID exemptions, and the New South Wales government told him to fly 41 tonnes of hay, i.e. dried grass, to Sydney and then put it on a truck and send it from Sydney back to the border, 15 kilometres or whatever it was, 10 kilometres from the border. So, how freaking ridiculous is that? That is obvious discrimination of him being a Victorian resident by New South Wales, as an example. You also have Section 92, again, which obviously affects him as well. Part of that is about trade and commerce, but another part is about the free intercourse. And it doesn't mean free hookers or free sex, but the free travel of people between the states and crossing internal borders. And that was also described, or what's a better word, interpreted by the High Court in 1989 in the Colin Whitfield case, also called the crayfish case or the lobster case, Tasmanian lobsters case. Sorry, I'm losing my voice again. To basically say, hey, look, you can have minor restrictions like, hey, look, you can't walk down the middle of the freeway, but besides that, people are allowed to cross state borders, internal borders. And you also have Section 69 of the Constitution, where the states gave up their quarantine powers to the Commonwealth government. Well, technically it was the colonies that gave up such power, but in other words, you can't have these COVID restrictions anyway, or the chief health officer of a state saying, or territory, saying you can't do X, Y, Z. It's all bogus. And anyway, so with my case, I have appealed it, and here's a copy of the document. So the file number is CA10191, and you see the respondents are the police officer, Dr. Jeanette Young, and the state of Queensland, and what else can I show that's interesting? So it's got a little court seal on it. So what a seal is in the olden days they used to melt wax and stamp it or whatever, but that takes too long and wax costs money, a lot more money than ink, so now they just stamp it, but it's still called sealing the document. That means it's been accepted by the court. And anyway, tomorrow what I'll probably do is go through some of the many questions of law that I came up with. Some could be worded a bit better, but such is life. I've got to do a lot of things in life, so as long as it's got the general gist of what I'm asking for. And I might go through some of the remedies that I'm seeking. Maybe I might even do that now. Just quickly check. Sorry about the computer shaking. And hi Renata. So Renata says, stay strong in your convictions, mate. Yep, I will. Thank you. Now, it's so easy for people to so-called dog something, as in just give up or whatever, but what's the point in that? Just quickly trying to check. Obviously, I'm not going to read through the whole thing anytime soon. Maybe when I win, if I eventually win, then I can do that. Also, I am soon to serve new or fresh version of the Section 78B of the Judiciary Act notices. So that's a Commonwealth piece of legislation. The Judiciary Act 1903 in Section 79A, it basically says that the Attorney Generals can intervene in any court case in Australia, and it doesn't matter if it's a federal court or a state court or, you know, local court, magistrates court, whatever you want to call it. And then Section 78B is that the court is not to proceed until they're satisfied. So I'm losing my voice again, going squeaky. But satisfied that a notice has gone out to all the attorneys general in Australia, so of each state and territory, as well as the Commonwealth one. And then so basically you fill out a notice and it says, hey, look, I've got this court case in this court. It is, you know, CA, what was it, 10191/20. That's my file number, and or case number, it's the same thing. And then you know, these are the questions of law involving the interpretation of the Constitution. Do you want to intervene? So they can get their usually the Solicitor General to appear. So Solicitor General's like the chief solicitor in a state, and the Attorney General is in charge of them as well, but the Attorney General is actually an elected person. It's a minister that doesn't use the word minister in its name. And anyway, so the other thing they can do, instead of just intervening, is they can remove the matter to the High Court. So they can say, look, this is important for all of Australia, which I suggest it should be removed to the High Court, but, you know, it concerns every state and territory about these COVID directions, so we should send it to the High Court and make it more generalised, so it's not just, you know, the directions are illegal in Queensland as an example, even though, you know, I've argued constitutional law as well, but that it applies to everywhere in the state. Oh, sorry, in all the states and the territories, and, you know, the Commonwealth itself. So really, I think that should happen. But I put these notices out, and then, you know, you got to wait weeks to get responses. Besides, hey, we've received it, and we'll consider it and let you know in time. But anyway, so I've got to do that. I've also got to put out to the human rights commissioners. You know, I'm going to do it to every state and territory one, not just Queensland, and the Commonwealth one as well, because they might well intervene. So we also just had 18 top lawyers and former judges come out in Victoria saying, hey, it's with their omnibus legislation. So basically the Victorian government is trying to strengthen their COVID directions and make it that they can appoint, you know, Joe Blow the plumber to go into your house and arrest you and whatever, because, you know, you supposedly have more than, you know, how many people are allowed in Victoria at the moment in a household that don't belong in the same household. So, you know, you got a party with 8 people, and then Joe the plumber knocks on your door, you open the door, and then it puts handcuffs on you or arrests you or whatever. And how ridiculous is that? But it's so ridiculous that some former judges and top barristers, QCs, it's Queen's Counsel, SCs, which is Senior Counsel, it's the same as a QC, it's just, about republicanism, really. So, just another historical thing. So, in Queensland, obviously, when Labor's in power, they try to instigate a republic. So they banned the terminology of QC and renamed it to Senior Counsel instead of Queen's Counsel, because obviously they don't like the Queen. Doesn't mean personally, but they want to be the next king or queen themselves, probably. Or possibly. So they got rid of the term, but then when I think it's when maybe Campbell Newman's government got in, they said, hey, look, sure, there's all these people want to call themselves SC instead of QC, that's fine, you can do that, but if you want, you can also, revert back to QC for a senior barrister. And apparently nearly all of them did, so that was quite interesting. So nearly all of the top barristers in Queensland are QC, not SC. And then below that you have a junior barrister that's, just a barrister. So, but a barrister, as I said in a previous video, is more superior than, a senior solicitor. Anyway, sorry for rambling a little bit, but what else was I going to say? Yeah, so it's encouraging seeing that, some top lawyers and former judges are coming out and suggesting that, it's unlawful or that it's not proportionate and adapted, etc. And anyway, so in the video tomorrow, when I'm more fresh and not just rambling, then I'll go through this filing and a little bit, so for questions of law, as well as some of the relief sought, which many people will be interested in. And, stay awesome. Please like, share, subscribe, and cheerio. Bye. And also special thanks to Earl, Mary, and Renata for watching and commenting too. I do like watching and reading the comments. I know sometimes I need to sort of power through the videos to try and keep it more interesting for other people, and then just do little batches of comments, but it is what it is. So thank you. Bye.